What are the matters that my spouse and I have to decide with regard to our children? Do all of our children have to be on the same plan? Is there any possibility that the plan that we come up with can be changed later? If it does have to be changed, or if we can't agree in the first place, how does a court go about deciding what our custody and visitation situation will be? I'm Michael Miller. I'm a partner at Cole Miller PLLC. We are a family law firm located in Vienna, Virginia. I analyze challenges and I find affordable solutions for families and their family law needs. So with this episode, we're going to continue our discussion of the 5 areas that are necessary to resolve a divorce. We start off in our first presentation was an introduction. And then our next presentation, we looked at the property and the debts issues. Those are the first 2 items. They both fall within the same statute of 20-107.3, but the property and the debts are treated separately because it's critical to keep track of the debts. As I said, it's easy to know where the car loan goes because it follows the car, but it's the unsecured debts and the credit cards and so forth that can cause problems. Then our third topic we make inquiry to is with regard to spousal support. We covered that previously. Today we're going to talk about custody visitation, which is our fourth topic. And then we'll finish up with our final and 5th episode on matters of child support. So today, let's take a look at custody visitation. And one of the things we notice here is with regard to property division and the debt assignment and spousal support, all those were with married persons. With custody visitation, it applies to parents whether they're married or not. So it's the same. Statutes apply and so forth. A marriage is not necessary. A divorce is not necessary for these things to apply. They also, for married persons going through a divorce, you would be in circuit court. For unmarried persons, or for married persons who have not filed for divorce, you would be in the juvenile and in domestic relations district court. So it's again, same courts or different courts rather would apply the same law. So we start off with some definitions. We can find these at Virginia Code 20-124.1. And what we're looking at here is matters of custody, which can either be sole custody or joint custody. Sole custody means that one person retains responsibility for the care and control of the child and has primary authority to make decisions concerning the child. And joint custody can come in a couple different forms. Joint custody can mean the joint legal custody where both parents retain joint responsibility for the care and control of the child and joint authority to make decisions concerning the child, even though the primary residence may be with only one parent. Joint custody can also be joint physical custody where both parents share physical and custodial care of the child, or it can be a third part of that, which can be any combination of joint legal and joint physical custody, which the court deems to be in the best interest of the child. So that's kind of the balance you're looking at here is legal custody is the power to make decisions concerning the welfare of the child. Physical custody is where does the child live. And as we've said before, kind of the modern term we're moving towards is away from the custody and visitation and more towards a combination of parenting time. With regard to legal custody, decision-making authority, in my observations and experience, it's for married persons, it's almost always joint legal unless there's some sort of reason that it be one parent only. For unmarried persons, it's almost always sole to the mother unless there's some sort of compelling or unusual circumstances to make it joint with the father. One thing we see frequently, I'm not really sure that that's a solution or not, is the court or the parents will, or one of the parents anyways, will propose, well, let's have joint legal custody. The parents have to confer and make decisions regarding the welfare of the child and so forth. But in the event they can't agree, then one person is granted authority to make the decision. And so you have to kind of wonder, how much good faith discussion is there in consideration that both parents have a chance to be heard when the one parent knows that ultimately in the event of a disagreement, they're going to have the deciding authority for the outcome. A couple ways to deal with that is what I would do is just say that, yeah, that sounds great. Let's do the joint custody, except let's make it my client instead of your client. And then you watch, the reasons why that wouldn't work come back in. Another thing you can do too is impose obligations of mediation or something like that, to have a third party come in to try to mediate or resolve disputes. And you can also put it in there that if somebody makes a decision, then the other parent has recourse to go to the courts to challenge that decision. Again, the big one that comes up here frequently is the choice of vaccinations. Other one that we see frequently is international travel. So those are kind of legal legal custody decisions that are being made, which then those are kind of separate. We put those apart because to an extent they are not frequently recurring. So for instance, if you have a child who is school age, as they come into that 5-6 year time frame, you consider, do you go to private school or do you go to public school? If you go to private school, then you follow through with that private school enrollment, or public school, then the child kind of goes on that track. So the legal custody decisions are significant, but they don't come up very frequently, because some of these things, like I said, with regard to school choice, once you make it, it kind of stays that way, for the foreseeable future. One other aspect of legal custody can be the choice with regard to medical treatment or health care of the child. Again, doesn't happen frequently that there's some sort of catastrophic illness or injury concerning a child, but you can see where, if the doctors are recommending, here's the traditional route of treatment, but we also have this other one out here, and the parents, possibly have a dispute or disagreement as to which course of treatment to pursue. So, legal custody, major items come up less frequently. With regard to physical custody, this is where the child lives, and it can be sole physical custody or primary physical custody to one parent, with visitation to be determined with the other parent. And some parents can get along and do that just fine, and they keep the flexibility in there without having a specifically designated schedule, and they proceed with that. Other parents, it's helpful both for the parents as well as the children to have a set schedule in there, so that they know that Christmases or Thanksgivings and even years or odd years will be with one parent and with the other parent, and what the summer arrangements are going to be and things like that. And some parents, you have to go clear to the other end and explain in great detail how to conduct a phone call, because for whatever reason, they can't figure out how to make telephone calls on Tuesdays and Thursday nights. So we have to go through, explain when the telephone call is going to occur, what the obligations are to charge phones or how to answer the phone, how long the child has to stay on the phone. And frequently the big problems here come up is the children that are 3 to 4 years old, that are old enough to talk but not really old enough to have the attention span to stay on the phone. And so there's always the accusation then that the parent with the child is distracting the child or drawing the child away so they don't complete their phone calls with the parent or something like that. When the parents go to ask the court to consider their circumstance, we look at Virginia Code 20-124.2. This says that a court may enter an order pending the suit as provided in Virginia Code 20-103. Okay, we saw 20-103 earlier in a discussion of spousal support, and now this continues again with regard to matters of custody visitation. Courts, I think, hate to do pendente lite or temporary custody visitation orders, and the reasons for that is that the time frames usually are not sufficient to have a thorough understanding of what's going on. And if the arrangements change, then you have some disruption to the children's schedules as they're on one schedule for a couple weeks or a couple months here, and then they switch over to a different schedule. So I think the courts want to give accelerated docketing so you can have one trial with enough time to get all the information out there to get one resolution rather than bounce back and forth on that. When the court makes the determination of custody, they will give primary consideration to the best interest of the child. And best interest of the child is a defined term. It's not what you kind of think informally it would be. It's specifically by statute at Virginia Code 20-124.3. The best interest of the child factors are contrasted to what some jurisdictions, not in the United States, but overseas, will use called the tender years doctrine, where the notion there is that a child of tender years should be with its mother. So in that instance, there's a strong preference for the mother, and then the father's trying to show what kind of time or parenting time he should be allowed to have. Certainly in Virginia and most of the United States, looking at the best interest of the child factors. The courts are to assure minor children with frequent and continuing contact with both parents. As between parents, there is no presumption or inference in law in favor of either one. Also, the courts are to give due regard to the primacy of the parent-child relationship. So, you may have grandparents, other relatives, other family members, and so forth trying to get involved. But again, it's the parent-child relationship is the primary relationship here. And there's a whole, discussion we can have kind of coming out of the U.S. Supreme Court case, Troxell versus Glanville, that talks about that. But essentially here, this provision is that there is an opportunity for what are called persons with legitimate interest, which a person with legitimate interest is broadly construed to include, but is not limited to, grandparents, step-grandparents, step-parents, former step-parents, blood relatives, family members, and so forth. So the idea here is if the child has formed a relationship, then this person with legitimate interest can come in to seek custody and or visitation, but they have a higher burden of proof. They have to show by clear and convincing evidence that that they should have these, custodial or visitation rights. And so that's kind of, the statutory authority that comes out here, talking about, how the court gets set up to make the decision. Now, as far as the actual substance of the decision, this is where we come into Virginia Code 20-124.3, best interest of the child. This applies for temporary measures, for permanent measures, for physical custody, legal custody, everything. Kind of go back a little bit. The one time where a court would do a temporary award is if a parent comes in and says that they've been, flat out denied any contact with the child, then that the court would say, well, immediately I want at least a dinner going on Wednesday nights or Saturday afternoon or something like that to have some sort of contact, unless there's a compelling reason to withhold the child from the other parent. We'll get something going and then try to get that hearing as soon as possible to come up with a better solution. Turning back to best interest of the child factors, there's 10 factors here, as we've seen previously with these lists of factors. The last one is always, in this instance, such other factors as the court deems necessary and proper to make its determination. So there's kind of the catch-all there that if you can't get a specific one and the circumstances of your case would warrant it, you can get it in there on factor 10. But factor 1, we're looking at the age, physical, mental condition of each of the children, giving due regard to the child's developing needs. So, so there's, age is pretty objective. It's the physical, mental condition where parents can get into a dispute as to, the legitimacy of what one parent would say is some sort of medical condition that the other parent, doesn't think that it warrants attention to. Factor 2 is the age and physical mental condition of each parent. This is where you can start looking at, bringing in mental health professionals who have been treating a parent, or really any medical personnel. They're doing that because in some instances there may be, physical conditions that would warrant testimony for the court to consider. So not only do you have the medical professionals that have established history of treatment, but this is also the occasion where experts could come in to examine the child or parties to provide expert opinion on these matters. Factor 3, we're looking at the relationship existing between each parent and each child, giving consideration to the parent's positive involvement in the child's life. And then the second part of this is the ability to accurately assess and meet the emotional, intellectual, and physical needs of the child. So this is, one parent has been primarily doing the meals, the baths, the transportation, and the other one hasn't. You have to look at, is it a choice and an allegation of duties in the marital partnership, or is there a lack of interest or a lack of ability? And, the court has to look at if they put that child with the other parent, will that other parent be able to meet these needs for the child, or to even assess them in the first place to know what has to be met. Then we look at factor 4, which is the needs of the child, giving due consideration to other important relationships, including but not limited to siblings, peers, and extended family members. So we'll talk here in a minute about where you could have split custody, where one child lives with one parent, the other child lives with the other parent. What you'd want to do there is set up the parenting time so that if the parents are alternating weekends, you have both children with the same parent, so at least the children are spending some time together as well. The role that each parent has played and will play in the future in the upbringing and care of the child, that's factor 5. This is where people start losing ground here when they're trying to get custody. They come in, oh, judge, I'm going to start going to parent-teacher conferences. I'm going to start going to the medical appointments, but, I have lots of excuses why I haven't been for the last 12 or 13 years. Factor 6 is the propensity of each parent to actively support the child's contact and relationship with the other parent. This is one that's easy to fall into when the parents first separate, and they're not facilitating access because of whatever anger or whatever that they're trying to use the child to retaliate against the other parent. Not good for that, because that leads into the second part of factor 6, is whether a parent has unreasonably denied the other parent access to or visitation with the child. And so that's kind of always the thing you look at is, during the period of separation, you kind of expect people to be on their best behavior, because both sides are, keeping notes on what the other one does. There's a trial coming up, the attorneys are involved in watching the circumstances. And so, everybody's trying to make sure that they're getting the positive marks of supporting the child's relationship with the other parent and avoiding the negative remarks of not withholding the child or something like that. Factor 7, we look at the relative willingness and demonstrated ability of each parent to maintain a close and continuing relationship with the child. And so that's where, you may be in different states. For instance, like the military member who may be assigned overseas, are they still able to make the phone calls home, have the video chats, the FaceTime, and other things like that to demonstrate and show they have the willingness to try to maintain that relationship. And the big second part to that is the ability of each parent to cooperate and resolve disputes regarding matters affecting the child. And this is where the emails and the text history and things like that come in, where you want to see a legitimate good faith effort to resolve matters, not a bunch of self-serving texts and email exchanges here where a person is obviously just trying to build the record for their litigation purposes rather than to solve the problem. Factor 8 is the big one that everybody wants to focus on, because that's the reasonable preference of the child. If the court deems the child is of reasonable intelligence, understanding, age, and experience to express such a preference. So everybody thinks this is a great idea. I'll have, my child come into court. He'll tell the judge what a wonderful parent I am. He'll tell the judge what a horrible parent the other parent is. And then I'll get the custody visitation that I want. Horrible idea. And in fact, a number of judges at various legal education conferences and so forth have said if a child comes in to testify, they don't necessarily look at it as a factor 8 of the child expressing a preference. What they look at it is more as has a parent been able to accurately assess and meet the emotional, intellectual, and physical needs of the child. If you're dragging a child in to testify against his other parent or her other parent, the appearance there is that you are not meeting the emotional needs of that child. So the other question that comes up that this touches on too is people say, well, how old does my child have to be? There's not a magic age of 12 or 14 or anything like that. And as the statute, the factor says, are they of reasonable intelligence, understanding, age, and experience to express a preference? So part of it is, what do they have to say? If a high school student comes in and says, I want to live with my father or my mother because there's a sports team that I've been on for the past, since I've been in kindergarten, and I'm coming up to be a senior, and I want to be the captain of the team, then that's, kind of an expression of understanding and to make a valid decision as to what they're trying to do for their best interest and things like that. Years ago, I had a case where the other side brought in he's probably like a 3 or 4 year old little boy, and there was a diplomatic family, so they got kicked out of their country. They were here in the United States temporarily until they sorted matters out. And he said, I want to go back to the foreign country because I don't know who's feeding my dog, and my friends are there. And it was, a touching concern, valid concern on his part, but not kind of the outcome here that the judge is going to give that a whole lot of weight. The other thing here too is, there's a reason that you have to be 18 years old to enter a contract and have a legally binding, position on this. And so even if this, high school student does come in and testify, it's only one factor out of 10 that, children don't tell judges what they're going to do. And there was one case, I had was a relocation, and the other counsel called in the daughter. She had just graduated 8th grade, and so this was the family tradition is, as each child graduated 8th grade, the father tried to move them out to his house to go to high school at his house, and she came in and testified, and the argument from the other side was, this young lady came in and testified, and the judge said, let me stop you right there. I disagree with the characterization. So again, it's not saying it can't happen, but the circumstances where having children testify is a good idea are pretty few and far between. The one place that it would be appropriate is factor 9, if there's any history of family abuse as the term is defined by statute, or sexual abuse. And if there is, not only is it a factor of custody visitation, but the court can further disregard the factors of subdivision 6, which has a parent unreasonably denied the access or has a parent actively supported the child's contact. So, if there is that history of abuse from either as demonstrated by protective orders, for convictions of assault on a family member, so forth, the court can take that entire factor 6 and excuse the parent who withheld the child or kept it from the other parent. Then the final factor there, as mentioned earlier, is the catch-all, is anything else that the court needs to consider. So with regard to, physical custody, if you have multiple children, you can have what would be called sole physical custody. So the children live with one parent, and then the other parent has their parenting time or their visitation. The next kind of step away from that then is shared custody, where both parents have more than 90 days. And to count as anything, it has to be at least an overnight to be a half. And then as you get closer to 24 hours, then you get to count that as one day. And that can be all children moving back and forth, or it can, the third kind of situation to be in is the split custody, where you take some children live with one parent, some children live with the other parent. And in that instance, it affects, the child support calculation, but you could have the younger kids stay with one parent while they go to the preschool or whatever, and then the older kids live with the other parents, they go to high school, whatever the case may be. And then even at that, Again, the groups of children don't have to stay the same. You could have shared custody of a couple children. You could have split shared custody of the other child. It's just a whole mix-up that goes on in there. And what we focused on here is just the substantive, aspect of making the decision of custody visitation. What we'll save for another day is the jurisdictional issues you have to go through. In our area here in Northern Virginia, DC, Maryland's not that far away. Pennsylvania and North Carolina, West Virginia aren't very far either. And so this is just a jurisdictional issue where we bring in here the Uniform Child Custody Jurisdiction Enforcement Act to look at that. So I think at this point, we've covered the foundation and the statutes that control custody visitation. There's a lot of other factors that we'll get to at some later date, but at least we've covered the groundwork here that we can build off from in the future.